of the Jacksonville Beach Special Magistrate hearing in accordance with Florida Statutes Chapter 162 and the City of Jacksonville Beach Code of Ordinances is to reach an equitable expedition to enforce the codes. The city presents the violation and evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation and evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard.
Thank you very much. I think I'm on now. Okay. I believe that we're going to start. The agenda begins with several business tax receipt items, and it's my understanding that City Attorney Mr. Miggett is going to be presenting on these items. Thank you.
Thank you. David Miggett, City Attorney, here on behalf of the City of Jacksonville Beach. With regard to the business tax receipt agenda items, items A through F have all, the violations have all been cured by the property owners. So those no longer need to be heard. And of the remaining items on the agenda for today, item G is the sole remaining business tax receipt related item, and we would be prepared to commence that item at this time if you so desire.
Well, let me first just ask the city, is it your desire for the items A through F as in Frank, for the special magistrate to issue an order finding those to be in compliance at this time?
Yes.
Okay, thank you. And so A through F, we will do, I will rule in that manner. And so please move forward with item G, which is item G, which is case number 24-215. The owner is Bad Bob 76 LLC, doing business as Susan Merrick Hair Designers. The violation is regards section 15-2 of the code, persons upon whom business tax levied and local business tax receipt is required.
And then before
I'll turn
we
it over to the city at this time.
I'll swear everybody in before we begin with that one. Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and position.
Jody Lynn Bird, Deputy City Clerk, Certified Florida State Business License Official.
Thank you very much. You may proceed.
And Your Honor, first, if you don't mind, I'd like to ask if anyone in the crowd here for this item, just want to see if they want to be sworn in. Looks like no one may be here at this point. So let me, I will question Ms. Bird. Thank you for introducing yourself. How long have you been employed with the City of Jacksonville Beach?
Just over 8 years,
And how long have you been employed in your current position?
2.5 years.
And do your duties include working with the city's business tax receipt program?
Yes, I oversee and supervise the program.
And what is the requirements of a business in the City of Jacksonville Beach with regards to a business tax receipt?
To obtain a local business tax receipt and renew the tax receipt annually.
And when are the business tax receipts due each year?
They expire September 30th of every year. Invoices are mailed out every year the first week of August. Second invoices are mailed out October 2nd. Follow-up emails are done within the first week of December. And then if needed, we have additional contact options that we do.
And where was such correspondence sent to Bad Bob 76 LLC late last year?
Yes.
And how many business tax receipts are due, would this business be subject to?
They hold two separate local business tax receipts. One is for the doing business as a salon and each chair that they have in the salon. And the second local business tax receipt is for miscellaneous retail sales as they sell products such as shampoo, conditioner, and other miscellaneous items.
And for those two business tax receipts, how much was the initial amount due?
The initial amount due was $79.20 for the retail and $79.20 for the salon before any of the fees and penalties.
And what are the latent delinquency fees that are assessed under our business tax receipt ordinance?
So the schedule for the fee is, if the renewals were not paid on time, as of October 1st, there's a 10% penalty. November, there's a 5%. December, there's a 5%. January, there's a 5%. And in February, after 150 days of non-compliance, there is an additional $250 fee added.
And have all those fees been assessed against this property?
Yes.
What is the total current amount due, including all late and delinquency fees for these two business tax receipts?
For the salon part, the total amount is $445.25. For the miscellaneous retail, it's $349, and that totals $794.25 that is currently due.
And this grand total amount is all due from Bad Bob 76 LLC, DBA Susan Merrick Designers?
Yes, sir.
Have you provided notice to them of their fees being due and any subsequent notices regarding delinquency?
Yes, again, the first invoice was mailed out, as all of them were, on August 1st. Second notices were mailed out, as all of them were, for all businesses, October 2nd. Follow-up email was sent to individual businesses on December 12th. Final call attempts by phone was between February 21st and 23rd, informing any business that the additional $250 fee was going to be added if not paid. April 8th, a legal notice was mailed, certified return receipt. And on May 8th, a notice of hearing was hand-delivered to the business, at which time the fire marshal stated that he spoke with someone in person there and they wanted to give him a check at that time, but he advised them to come into the city clerk's office to pay, and no one has, and we have not had any communication with the business.
Did anyone sign for the certified mail?
No, I don't believe so. But a letter was also mailed out, regular mail as well.
Excuse me, Counselor, could you give me the date that the fire marshal visited the site?
May 8th?
May the 8th?
May 8th.
Thank you.
And have you had any other correspondence with this business other than what you've already testified to?
No, sir.
Have they made any other efforts to contact your office to set up payment or otherwise dispute this?
No, sir.
this time, we would proffer the testimony provided as part of our case in requesting that you find the property owner guilty of this violation.
Could you clarify, I have thank you very much, I do have a couple of clarifying questions. On the April 8th mailing, you, if I may, through the city attorney, if I may, you mentioned that the April 8th, there was a mail letter and a certified letter. Was the certified letter returned to the city?
If, Your Honor, can I refresh the witness's recollection?
Yes.
I'm going to provide this document to you, and then I'll provide it to the judge, the magistrate. Do you recognize this?
Yes, my apologies. It is a signed return receipt for the
Is that
business.
for that specific property that we've been discussing?
Yes.
And did someone in fact sign that?
This address, I believe this one was the registered agent.
But has someone signed that
Yes,
that was
someone
received?
signed for it, yes.
And based on your involvement, is that a true photocopy of the card that was received back from the U.S.
Yes.
mail?
Yes.
Your Honor, may I approach?
Yes, please.
We would ask that this be entered into evidence.
Okay, this is a copy of the signed return receipt for, it was dated April 11th, 2024. The article was addressed to Bad Bob Dukes Jr., that its registered agent at 1301 River Place Boulevard, Jacksonville, Florida. Does the city know who the actual property owner here is? Is it this particular business? And because in looking, and I'm asking this question because I'm concerned about the entities, the formal status of the entities. In looking at Sunbiz, neither Susan Merrick Hair Designers or Bad Bob 76 seem to be currently registered with Florida Division of Corporations, which is why I'm asking about the property owner for the property, whether it's one and the same. It doesn't mean that they shouldn't have paid a business tax receipt, but I was wondering if you can tell me that you were able to confirm that, but through observation of the business or any other evidence that you might have, that the business there is still being operated under these names.
Could I respond by eliciting testimony from the witness?
Certainly.
Okay. Ms. Bird, are you familiar with this property from previous year's business tax receipts?
Yes.
And have you reviewed the Florida Division of Corporations records related to this property?
Yes.
Do you recall when the entity known as Bad Bob 76 LLC was dissolved? Let me step back once. Do you know if Bad Bob 76 LLC is currently an active corporation on the Sunbiz website?
I believe it is not.
Would that have been because it was dissolved for failure to file an annual report?
I would assume so, yes.
Do you recall when that dissolvement took place?
I do not.
Okay. And Your Honor, if you haven't already looked it up, I think we could take judicial notice of whenever that dissolvement was. I believe it was in 2016. That's not testimony. The records should speak for themselves. But I just wanted to say that just prior to my next question is, have they paid in all previous years, and did they pay their business tax receipt a year ago?
Yes, they did.
and the year before?
Yes, they did.
Do you have any knowledge of them not paying their business tax since you've been responsible for this program?
No, they have paid late other times, not to this extent, but a month or so late, but they have paid every year.
And Your Honor, to get back to your question, if I may address it, it's a valid point, but I think the testimony shows that we've had customary dealings with this business. They've always paid. I believe, again, this isn't testimony, the records would speak for themselves, but I believe the entity may have been dissolved many years ago. We don't have the resources to check every single business every single year. We do, we check as part of this. And if you need testimony on this, I'll gladly elicit testimony, but, the staff looks at businesses as needed when payments not coming in. We have no knowledge or no reason to believe that it's not the same entity. And I think the records demonstrate there's been a customary history with this property that would show there's nothing of suspicion to us or that would raise any sort of concerns with us as to a different owner of the property.
So to your knowledge, to the city's knowledge, they're still holding themselves out as Susan and Eric hair designers? Is that?
To my knowledge, in the sign outside of it's in a shopping plaza, and the sign both on the shopping plaza wall and on the door reflects Susan Merrick.
Okay. Is there anything there that you observed referring to Bad Bob 76 LLC?
No, nothing other than the Sunbiz.
And are you familiar with someone named Jamie S. Talley, Talley?
No.
Okay.
I did drive by there myself yesterday. The business was closed at the time. The sign was still there. I did look inside and it did seem as if it was a full functioning salon. The electricity was on. They just were not open at the time.
So there were chairs there, it looked like.
There was product on the shelves, yes.
Okay. Is there any other testimony that the city wants to offer?
Just a brief closing statement, if you'll allow it.
Right, hold on, let me look at my notes if I have. I do have one other question. The ordinance code allows for attorney's fees, reasonable attorney's fees to be charged against someone. And I know in one other case before this prior special magistrate that attorney's fees were found to be due to the city. Are there any attorney's fees in this particular instance that the city is seeking?
They are minimal. They are, if you need that to be under oath, because I think I'd be speaking more as a witness than a lawyer. I'd gladly go under oath, and we would ask for, if you're so inclined, for recovery of the actual attorney's fees expended.
Okay, well, I would need to hear what that information is, and so that I could include that in the order.
Would you prefer I be sworn in, so my statements under oath, the factual statements?
I think that'd be fine.
Okay.
Please raise your hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your position.
David Niggett, City Attorney, City of Jacksonville Beach. Your Honor, in this case, I incurred a little over 3 hours of time, somewhere between 3 hours and 3 hours and 15 minutes of time, to review the facts of this case. Admittedly, it did include reviewing the ordinance in general, because this is the first case like this I've handled at this jurisdiction. And then my base hourly rate, which would not include public sector, so I don't bill the client on an hourly basis, but just salary, not including any other benefits, hourly rate would be $98.56 for, I think the best way to describe it would be 3 1/8 hours of time. 3.125.
Okay. Thank you.
I don't bill by tenths of an hour like private sector attorneys, so my math, I think 1/8 is 0.125. So,
1/8 of an hour?
yes,
Yeah, I don't actually know, but I'll figure it out. So what you're saying is it was 3 hours plus 1/8 of an hour?
yes.
Okay, thank you. I don't have any other questions at this time. Is there any, I know that this was asked previously, but is there anyone else in the audience who wishes to speak on this issue? Okay, seeing none. And is there any closing that you wish to
Just
conclude?
very brief. I think that the testimony today has shown that the ordinance is applicable, that the business was provided notice, multiple attempts were made at notice following the procedure required. The amount has not been paid. The amounts that would be due under the ordinance, including delinquencies, has all been tested. Those amounts have been testified to by the staff member, and therefore we would request an order finding them in violation and awarding all the costs, delinquency fees, and attorney's fees that are allowed for under the code. Thank you.
Thank you. I will be ruling in the city's favor on this item, and on all the requests made, and be publishing an order on this matter within the next 5 business days.
Thank you.
Thank you very much. If you'll just bear with me.
No problem, I just dropped in.
Moving on to the next item is item H, case number 24-200. The property owner is Gary Anderson, and the violation address is 505 Palm Tree Road, Jacksonville Beach. The alleged violation is for violation of section 34-402, parking of heavy vehicles in RS1, RS2, RS3, RM1, RM2 zoning districts, or residential uses in the RD or PUD zoning districts. Please proceed.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your position.
Nikki Beaver, City of Jacksonville Beach Code Enforcement Officer. As stated, the property owner Gary Andreessen at 505 Palm Tree Road, case number 24000. This was in regards to a recreational vehicle that was parked in the city right of way and also not part of the setback requirements. After further investigation, as you can see, this is where it was parked on Exhibit A. Exhibit B, we did do some investigating and found that the property owner did have a variance. So where his front door, as you can see on here, is actually considered his side yard. Once he got the variance,
Could you go back to the photograph, please? Do you have a pointer that shows where the,
I don't think it's a pointer on here.
so it's.
So this is the front of the house that's on 505 Palm Tree. So typically that's normally someone's front door where their address is. This property is located on a corner lot. And once the property owner obtained the variance, the largest area of, as you can see on the survey, is actually on this bottom front where I wrote front at, is a shed. That's actually, it looks like it's the side of the house because there's no door, there's no address there. But once he obtained the variance, this was considered the front of the house, and where the Airstream is parked is now considered his backyard.
Okay, I have some questions about this. In the future, it'd be really helpful if you have a pointer,
Okay.
because the descriptions are pretty confusing.
Yeah,
Why-
surveys are confusing.
Sorry to interrupt, but there is a pointer, it's a little line on there.
This, okay, there it is. Okay, great.
Okay, so
So you want me to go back to the other picture?
that'd be great just for
Okay.
a quick second.
So what did you want to see on this one?
Where you said the front door is.
Oh, right here,
Okay, and so,
and the address
and
of the
are
property.
is this picture taken from,
505
Palm Tree Road?
Correct.
And what is the other street then that you
It
said?
is 4th Avenue.
Okay, Fourth Avenue. So are you saying now that Fourth Avenue is technically the property's front?
Yes, so right here, this is now, because as you can see, the 30 feet, this is the largest part on the survey point from the actual structure, so this would now be considered his front yard. So on the variance,
Oh, okay, go back.
okay,
What is the street at the bottom of this picture?
on the bottom of, right here,
Yeah,
this is 4th.
so that's
But-
Fourth,
Yes,
but you just said that Fourth Avenue is considered his front yard.
yes, but his address is listed as 505 Palm Tree Road.
And was the Fourth Avenue determined to be his front yard based upon the variance declared, was that declared in the variance?
Correct.
And when was the variance granted?
The variance was granted, this was April 19th of 2000.
And was that, granted to the current landowner?
Correct. So being that we,
Do you have a variance number or a case number for the variance?
yes, the case number is 31-2000.
I'm sorry,
31-2000.
31 dash,
2000.
that's the number of the variance.
That's the case number.
Okay.
So after speaking with our planning and zoning department and obtaining this information, the property property owner is now considered in compliance.
One more question. Where on this drawing that you're showing us, Exhibit C, where is the RV located?
Right here, next to the driveway, where the front door is. And there's where it says future garage. This is where I've got the orange mark, that's where the Airstream was parked.
So is that considered a side yard?
It is actually considered his rear yard. Based on the variance that he obtained now, well, back in 2000.
And based upon it being in the rear yard, does it now meet the setbacks and is no longer in a right-of-way?
Correct.
Did the variance change the right-of-way area?
Yes, because now this is considered his rear yard, and he can park the Airstream and meets the setback requirements, as you just stated, and it's no longer considered being parked in his front yard, which is, prior to learning all of this, just driving up and you're seeing the front door, you're thinking this, and this is where the address is, that this is someone's front door. Because where it says front and shed, there's no door, there's nothing right there but a wall.
Okay. Is there anyone else, is there anything else?
No, it's complied.
Okay. Is there anyone else in the audience who wishes to speak on this item or a party to this item? No. Seeing none, then we'll close this testimony. I will find that, compliance has been had. I appreciate the facts because I will add those to the order.
Thank you.
Thank you.
All right, moving on to case I, case number 2346. This is, the property owner is Joseph Benza, address 1023 North 14th Avenue. This was in regards to no building permit being obtained. No, I'm sorry. Yes, this is in regards to no building permit being obtained for level 3 renovations. The property owner is currently in progress. They had a rough inspection yesterday, and my only recommendation is for them to obtain a certificate of completion once all renovations have been completed and the final inspection has been obtained.
So you want them to get a certificate of completion, and what was the second thing? Once all the renovations are complete?
And obtain a final inspection from our building official.
So you're saying that in fact they did obtain an appropriate building permit?
Yes, they did. So everything is in progress. The building permit is good for 180 days. And they did have a rough inspection yesterday.
And do you have information on when the building permit was actually issued?
Not with me today.
Is it safe to say it's sometime?
They still have
After-
plenty of time. They still have about 60 days.
After you issued the notice of hearing to them?
Correct.
Okay. And how many days do you want them? Usually,
We'll come back after they obtain the certificate of completion and have their final inspection to finalize the case and close it.
so you want me to basically continue the hearing?
Correct.
Do you want me to continue it to the next, to the hearing in June?
We got June coming up, so I would say let's do September.
September?
Yes.
Okay, just to, I hope I didn't already ask this. Just to confirm, there's no one in the audience, party
you can come up just for a second.
Well, we'll have to swear him in.
Yes.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Joseph Benza, 1023 North 14th Avenue.
So my question was, do you know what's the time frame of when you probably be?
So now we talked to Mr. Stuck yesterday,
Mhm.
and so the contractor is actually there now.
Okay.
He's finishing up. So he said probably 2 months or so,
Okay.
but
So September is.
yeah,
Okay.
that would be probably accurate.
Okay, so, as I stated, once you complete that, get that certificate of completion, if, you could just let them know in our building department to contact me, so then we can come back, and then we'll close the case. Okay.
Okay, thank you very much,
Thank you.
Mr. Benson.
Appreciate it.
Thank you.
I will, as the city's requested, continue the hearing until the September hearing.
Okay. All right. Moving to J, this is J.R. Rushing at 620 South First Street, case number 22603. This was in regards to no building permit being obtained. This is the main structure at the property. This was part of a shed that was constructed without a building permit. About 85–90% of the shed has been removed. And let me see if I can get it. Okay, here's another picture. As you can see right here, this is what's remaining of that shed. And if the owner decides to keep that, he's been notified that he still would have to obtain a building permit for the shed.
Okay, and I recall that this item has been before us
Correct.
in the past, and I believe that your testimony is the same. Is it the same as
Correct.
it was the last time that this came before us?
The order stated that either he obtained a permit for this structure or to remove it. And as you can see, this picture is dated May 22nd, which is today, and the structure, it has not been removed and no permit has been obtained. I did speak to the property owner. He was not able to be here today due to an accident that occurred. I did inform him that a daily fine would be assessed until the building permit has been obtained or the structure has been removed.
And what is your recommendation regarding the fine?
$100 per day.
You said that you spoke to Mr. Rushing,
I did.
and did Mr. Rushing indicate that he would indicate at all that he would be obtaining a building permit?
Correct, so he
Is
did
that his
state,
desire to obtain a building permit?
yes, he stated that the tenant, that was previously, he was renting to build the structure and left him with the responsibility now of having to remove it or obtain a permit. He said he would be in our office sometime this week or next week to obtain that permit, so he was advised until that permit has been obtained that the daily fine will accrue until then.
Does the city wish to give Mr. Rushing, in light of the accident, I believe that you said that he,
The accident happened yesterday, so he's been knowing since we brought this before you in the beginning that this structure had to be removed.
okay, well, then, I gather there's no one
Yeah, he's not here.
in the audience on this item? Okay. Seeing none, I will, take the recommendation of the city for $100 per day, beginning, as of today.
Yes.
And, that will begin in the order, he will still have the option to remove. So that still remains an option for him.
Yeah, that's fine.
Thank you very
All
much.
right, thank you. All right, moving to next on the agenda, K. This is case number 23-62 ACA Investments LLC at 412 North 7th Street. Case number 2394. This is in regards to no building permit being obtained for an accessory structure, which is the Connex container that you see right here on the right-hand side. And these were just more photos of that container. Mr. Middlebrooks has also been here. This is a continuance. As you can see, work was in progress in regards to having the container moved. As of today, May 22nd, in Exhibit E, you will see that the container has been removed and moved to the proper location. And this is in the rear yard. This is the final picture in Exhibit F. My recommendations today is for Mr. Middlebrooks to obtain a final inspection and get the certificate of completion to close the case.
And do you have a time period that you believe that that would be appropriate?
We can come back in June.
In June, so by no later than the June hearing.
Yes.
Is there anything else that, on behalf of the city at this time?
Not for that case, but I have one more.
Right. Is there anybody in the audience on this item? Okay. Thank you very much.
Our last case is L on the agenda, case number 23-130 for 1121 North 3rd Street, Inc. at 1121 North 3rd Street, case number 23-130. This was in regards to outside display of merchandise and sales. We were here, this case was.
My name's, I'm sorry, I didn't interrupt you.
Okay.
I'm here on that case.
Uh-huh.
My name's Panton Poe. I'm here on behalf of Tigra and Marina Village, the store.
Just wait, because first off, you're not being recorded.
Oh, okay.
And
I'm
so,
sorry.
wait just one moment. We can either swear you in now, or after the presentation.
Oh, that's fine. My apologies. I haven't been to one of these presentations before, and so I just thought since you were calling the case, I should announce myself. I didn't mean to interrupt anything.
Okay, thank you.
Absolutely.
Okay. This was a continuance, a case that was started back in September 21 of 2023, in regards to the outdoor sales and display. That case, the order was issued, November 29th, that the property remained in compliance, in regards to not having the merchandise outside for any type of display or sales. As you can see, on May 2nd, I did observe the merchandise back out in front of the store. This also is in the parking lot, and they have a flag, and then they also have a A-frame sign that is also out on display. So I did speak to Mr. Patel. I'm sorry, am I saying it right?
That's okay. It's Poe.
Poe. I
That's
did
okay.
speak with Mr. Poe. I did get a phone call and an email from Mr. Poe stating that he was the new owner. Also, when I went into the store on May 2nd, Chris, who was here during our last hearing, is still employed there. And he advised me that the store now has a new owner. And I did advise Chris that even with the change of ownership, that the order remains in place, that compliance of the merchandise being outdoors was still prohibited.
Do you have information on who the new owner is?
Mr. Powell.
Okay.
reminding him that the flag and the A-frame sign, any of the merchandise is not allowed.
And were those the same items or the same type of items that from the
Yes.
November hearing?
Yes,
So this would be considered a repeat?
correct.
Okay.
Now, as far as the change of ownership, my recommendation today, being that Mr. Powell was not notified of the previous order, that no fines be assessed today, and that order just states that compliance is to be maintained.
Okay. If you would please come forward
Sure.
and state your name and address for the record.
May I come to this
Also,
table?
certainly, and also, if you would, I don't know if you're an attorney or you are, but you're here as the owner of the property,
Yeah.
not representing a party.
Well, I essentially was here. So as background, yes.
You need to move
Would
over
you like me to be
here.
here?
And, yes, so that, where the microphone is located.
Can you hear me okay, Your Honor?
Yeah, but you can move it up so you don't have to.
Can you hear me now? Does that work? Thank you. All right. Respectfully, and I'll try to be very respectful of your time, but I'll give you a little bit of background. You are correct. I am a lawyer. I've been a lawyer since 1997, so I'm a
Could
lawyer
you
for
state your
25
name
years.
for the record?
Yes, my name's Panton, Panton. Last name Poe, P-O-U.
P-O-E,
P-O-U. It sounds like P-O-E, but it's spelled P-O-U.
P-O-U.
Correct. So, yes, I am a lawyer, and I also am the owner of the business that operates as T. Gregory Imports there.
What is the name of the business?
So, T. Gregory Imports, Inc. has been the business that owned T. Gregory, the store there, that's been there for over 20 years, operating just as it is. On December 29, 2023, this last December, my company, who we started just for the sole purpose of buying this business, Pink Moon Imports LLC, purchased,
Could you say that name again?
yes, Pink, the color pink, P-I-N-K, Moon, Imports,
What was the?
Imports,
Imports?
I'm sorry, Pink Moon,
Moon.
M-O-O-N, and then Imports, LLC.
Did you buy the property and the business or just the business?
No, just bought the business. So Pink Moon Imports bought the business assets of T. Gregory Imports, Inc. All of the business assets, which includes 4 stores. This is one of 3 locations. And bought the name T. Gregory Imports. So if you look on Sunbiz, T. Gregory Imports is a fictitious name owned by Pink Moon Imports LLC. And Pink Moon Imports LLC is owned by me and my wife. We started it to buy this business. Right?
You're listed as the managers.
That is correct. My wife is Stephanie Powell. And we are both listed as the managers. That is correct. So, rather than go through that explanation every time I say it, I'll say we bought the business at the end of December, on December 29, 2023.
So I need to know whether to
Yeah.
swear you in.
Oh,
And,
sure.
it's up to you, but I believe that as the manager of the business that owns the business, that would be different than you representing, in your role as a lawyer.
Correct.
So, if you're going to be testifying about facts, that it may be appropriate for you to be sworn in. If you are, if you're arguing for position, then obviously those are not facts that's in your capacity as a lawyer. So I don't know what you're going to be testifying about, so I leave that up to you, whether or not you want to be sworn.
I'm happy to be sworn in. I don't have a lot of facts to testify to. It's mostly argument, but I will probably testify to some facts, and I also have some questions for Ms. Beavers. So I'm happy to be sworn in.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
My name is Panton Poe, P-O-U. My address is 333 11th Street, Atlantic Beach, Florida. That's my home address.
Did you say 333 or 33?
333. That's my home address. So what I had intended to do was introduce myself, which I think I sort of just did, and then listen to the presentation of the basis of the citation, which I think Ms. Beavers did, and then I had some questions that I wanted to ask Ms. Beavers, and then I probably have maybe some testimony and maybe and definitely some argument that I'd like to make. But essentially, Your Honor, and let me say this, Ms. Beavers has been very kind and responsive when I've reached out to her, and I think that Ms. Beavers has been trying to be, helpful and is, doing things as in an outstanding way. I mean, with all due respect, I've had very pleasant dealings with Ms. Beavers so far. That said, respectfully, I do not believe a violation exists. I do not believe there's been a violation. So I want to argue, my two main points will be, there's not a violation of the code sections that have been cited. There hasn't been a violation of the code sections that have been cited. And if you find that there's a violation, then unfortunately, and this is nothing against Ms. Beavers, but there's been selective enforcement, and the enforcement's been arbitrary. And for both of those reasons, the citation really should be dismissed. While I appreciate very much that Ms. Beavers has been understanding that we're new owners to the business, and I want to express very clearly that as new owners of the business, this business has been here for over 2 decades and has been operating as it's been operating for all that time. Now that we're new owners, we certainly want to continue that tradition, and we certainly want to work with the City of Jacksonville Beach to comply with all applicable rules and be really good stewards and citizens of business in Jacksonville Beach. In looking at the way the ordinance is written, I don't think that there's been a violation. So, Your Honor, would you like me to start with a more in-depth, statement or opening argument, or
You can start
some
wherever.
questions?
That's up to you. You
Okay.
decide.
Thank you, Your Honor. Ms. Beavers? Let's see. Shoot. I apologize for the delay. Here it is. Ms. Beavers, we're here about a notice of hearing that was issued on May 7, 2024, is that correct?
Correct.
Okay. And that notice of hearing was delivered by certified mail to 1121 North 3rd Street, is that right?
Correct.
Was it sent anywhere else?
It was also sent, and it was also posted on the front door.
Okay.
The address that we had on file was the 1121. And I believe that's that would be the only address that it was sent to. It was sent to the 1131 3rd Street North, Inc. at 1121 3rd Street North. And then the second notice was actually placed on the front door.
Okay. And I think you said 1131, but I think you meant 1121, right?
1121.
Yeah. Okay, so that's the address of the store, is that correct?
Correct.
Okay. And it's issued to 1121 North 3rd Street, Inc. Is that right?
Yes.
Okay. In the citation or the notice, down at what I guess we would call the third paragraph, says it is for violation of code 34-34, I'm sorry, 34-342K, is that correct? Which is what you have up on the screen right there.
Yes.
Okay. And that is the violation that we are here about. 34-342K, prohibited use, the business of outdoor advertising. Is that correct?
Correct.
Okay. Any other violations that you observed for which we are here today?
The other violations that we just spoke to you verbally about, and I have the email from you stating that you would be in compliance with, was the flag that was displayed and the A-frame, which me and you had a phone discussion. I did not cite you for it because you stated you were the new owner and you were not aware of those violations. So based on your email, you stated that verbatim, we will bring those in and we will discuss further on May 22nd. In my email, I also stated that I observed the A-frame sign and welcome flag today, and that you were not in the central business district, and that those were not allowed. So that was a courtesy notice letting you know what the ordinance states in regards to the flag and the A-frame. So no violation was cited for those, but as far as the outdoor display of the merchandise, you were cited for that.
Understood. And I appreciate your courtesy. And as I said before, I think you've been very courteous. I just think that there's a disagreement about what the law actually, how the law actually applies. And so,
Excuse me.
Yes.
What were the dates of those email?
May 15th of 2024.
I have a copy of both of them.
I haven't read it.
Okay, great. So there was a May 14th email. I think we spoke on the phone on May 14th. Is that right?
I don't recall exactly what date it is.
Okay.
But the email was a follow-up of our conversation. And in our email, I sent you the section for the sign, for the flag, stating what was allowed and what was not allowed.
Right, I understand. So that was on May 14th you sent the email. Is this a copy of the email?
Yes, I have it.
Okay. I just was going to present it to you.
May I see it?
You absolutely may. I want you to confirm that this is the copy of
Yeah,
the
I'll
email
get
that
it.
we're talking about.
Okay.
Well, I was going to give her this one. This is the one I brought to get.
Is it accepted?
I didn't see that one.
Do you want to see it?
I would like to, yes, thank you. May I have it? Yes, sir. Thank you. And I'm sure.
For the record, I've received in evidence a series of emails. There was one email dated May 14th at 11:33 from Ms. Beavers to Patton at T. Gregory Imports, and then a response from Mr. Poe, to Ms. Beavers on May 15th, 2024 at 11:49 a.m.
Oh, does that have, I'm sorry, may I see that again? Does that have both the May 14th and May 15th emails?
It has a May 14th at 11:33 a.m. Oh, you're correct. There was that was to you,
Correct.
Mr. Poe, from
Correct.
And then your response, at 11:49 a.m. to Ms. Beavers. And the first subject was outside display and sales. That's for the May 14th correspondence. I don't see any response from you in regards to that. Course, email from Ms. Beavers. The next one on May 15th at 11:37 a.m. The subject matter is A-frame sign / flag. And that is the one that you responded to at 11:49 a.m. on the same date, May 15th. So that's what I now have that refers to the 34-342K provision, the prohibited use business of outdoor advertising. And it also refers to 34-444, parens 15, flutter signs, feather signs. And there's a reference that this is for the quote, welcome flag.
Thank you. May I continue
Yes,
questions? Ms. Beavers, I think this is a copy of the order that you sent me from the prior matter.
Correct.
Earlier in this particular.
The
case.
November 29th.
May I present this to the judge?
Yeah.
May I present
Yes,
this?
please. I see that this order from November referenced violations of 34-342B as in boy, 342C, and 342D as in David. Is that correct, Ms. Beaver? Was that what the violations were for at that time?
It should have been for what all the previous hearings were for the outside display. So it looks like K was not listed on here, but it all falls up under the 341, 3442 list.
So I have a copy of 34-344-2. Does this look like?
I have one more question about the order.
Yes, absolutely.
To Ms. Beavers.
Mm-hmm.
It says that this matter was previously the subject of order number 33-23, which determined that the respondent owns the business.
Where are you reading it?
In the first paragraph.
3323, okay. Which determines the respondent, that was the previous owner that was here. And then it also states the
Well, the
respondent.
owner is still the same.
No, the owner has changed.
No.
Okay.
The property owner is still the same.
As far as,
As this piece of
you
property.
saying the property owner or the business owner?
Now I'm talking about the
Property owner, okay.
Who is actually the responsible party. According, that's who is responsible for, the violation. We can't, that's the only information that we actually have, is who the property owner is.
So I'm not understanding what Mr. Poe's argument is in regards to,
Well, I don't think he's gotten to it yet.
okay. Because it states also in here, in regards to the sale of personal, what it says, the banner with the word sale on the outside of the building of the property,
Right.
displayed items sold on the premises outside of the building, but on the property as well as in the open parking lot adjacent to the building on the property, together with balloons attached to some items for sale.
Right. So what you're saying is that those descriptions are exactly what's happened this time,
Correct.
even though it didn't specifically reference the correct section.
Yes, as far as K, yes.
Okay. You may proceed, Mr. Poe.
This is a copy of 342. I just wanted to run it by you and see if it looks like what you
I'm
understand
sorry,
the rule to
you
be, and
need
then I
to
will send that.
speak into
Oh,
the
I'm so
microphone.
sorry. Ms. Beavers, this is a copy of 342. I wanted to admit that through you and present it to the judge. Really, it's just a matter of law, but, and she probably has a copy of the code. That looks like you're looking through your notebook now, Your Honor.
Which code
The code
section?
is 34-342.
Yes, that is correct, because it should have been K, let me see, you don't have K listed on here. And you don't have section 34-341.
I'm not sure what you're saying. I don't have case on there.
What is K, okay, oh, okay, the prohibited
Yes.
use of outdoor advertising, okay. So, again, what is your argument?
Oh, I haven't gotten to that yet. I'm trying to, get out some facts for the judge to consider and make sure that I understand the facts correctly, and present these documents to the judge. And then I do have an argument. My argument is that there's not a violation of 34-342K, and there hasn't been one
So,
at the property. But I'll get to that.
okay, because this is clearly outdoor display of merchandise for sale.
So, I don't know whether you've seen this before or not, but as you'll recall, you and I communicated, and again, I think you were very gracious, and I appreciate you getting back to me so quickly. But I had asked for information as the emails exhibit. I wanted to understand better what was happening at the store with a welcome flag and some furniture items out by the front door. I wanted to understand what ordinance that was a violation of and why. And you explained that it was a violation of K. And so I followed up, as the emails show. Is there any further, explanation of what this means? And I trust you didn't have anything further, because that was it.
This is what was provided to me by our planning and zoning department.
Understood. Have you reviewed the ordinance that amended the code and added K back in December of 2015? And the ordinance was 2015-8065. It was amended, it looks like, back at the end of 2015. And this is a copy of that document. I don't know whether you reviewed that or not.
I'm not sure, I don't recall if I actually looked through that.
Okay. And I don't know if that would be something that Your Honor would have a copy of, but I can give you a copy of it. I'm sorry,
I do not have a copy of it.
may I approach and give you, I only printed one copy of it. I'm happy to show you the copy that I have as well as if the judge has any.
Can I take a look?
Yeah, absolutely, absolutely.
So, can you tell me what part of this amended ordinance states that you're not in violation? And what are you not in violation of? Because this looks like this is in regards to signs.
And Your Honor, it really is up to you. what I'm accustomed to is sort of going through the questions and then doing an argument at the end. If we want to be more formal and have it more conversational, I'm okay with that, if that's what you would prefer.
This is the amended sign.
Well, I think it's appropriate for you to, if you're going to present this document, what
Sure.
is the purpose of that?
The purpose of the document is, it's a 52-page document, and it goes through explaining when and why the code was amended, adding K. And this, the council make very clear throughout this document that, and this is what struck me, and I really kind of wanted to put this together, and I've got an argument that I was going to present, but I can jump around. When I saw that the violation was for K, prohibited use, the business of outdoor advertising, it immediately struck me that that's not what's happening at our store. The business of outdoor advertising is what Clear Channel does with billboards and what outdoor advertising companies do when they sell signage to third parties on billboards. Or for example, if our store was selling a mural to Coca-Cola to advertise on the side of the building, or selling advertising space on the property in some form or fashion to third parties. It immediately struck me that that's what this prohibition was about. And so I asked questions and said, Ms. Beavers, can you explain how this is a violation? And she said, you can't have anything outside. And I get that that may be what's been discussed or explained in vernacular, and I did a fair bit of research, and if something's out there that I missed, my apologies, but I looked quite a bit, and I found nothing to suggest that that would be a violation. But but the business of outdoor advertising, quite clearly, is not what's happening. The business of outdoor advertising is if we had a commercial enterprise to sell advertising on that property, like the billboards. And so I found a couple places where that is clear, and I can get into further argument in my testimony presenting what I found. But one, I found this ordinance, and I can direct you to multiple places where it makes quite clear that when they added K to the code, let's go to, if you'll see there's pages at the bottom. If you turn to page, I'm trying to go in order. Page 11, towards the middle. It makes a distinction. Whereas the city of Jacksonville Beach finds and determines and recognizes that on-site business signs are considered to be a part of the business itself, as distinguished from off-site outdoor advertising, right? And that's where it's going through and explaining. There's a whole bunch of whereases where they explain why they have the power to make these changes and why it's appropriate to make these changes. But importantly throughout, they make a clear point that these amendments were in part for the goal of regulating off-site advertising. They didn't want 3rd Street cluttered up with billboards by third parties advertising. And in fact, it says quite plainly in here, one of the many benefits of disallowing billboards and property owners putting up billboard signage by third parties, such as Clear Channel and Outdoor and all those different companies that do billboards and signs of that nature, is that it will better allow on-site the actual businesses advertising to be seen, right? So this is talking about, again, on page 12 at the 3rd paragraph, it talks about the purpose is to regulate off-site advertising signs. And then on the next paragraph on page 12, 1, 2, 3, 4, it says one of the benefits is to increase the visibility and readability and or effectiveness of on-site signs by reducing the visual clutter of off-site signs. Then on the next page, on page 13, it says, basically the first whereas on that page, whereas the city of Jacksonville Beach recognizes that the distinction between off-site premises and on-site premises signs is, and then it draws out a distinction. it goes on in the next paragraph to again say it's permissible to distinguish between on-site signs and off-site signs. And then in that third whereas, it says the city of Jacksonville Beach finds and determines consistent with the foregoing preamble that the business of outdoor advertising should be prohibited in use of each city zoning, and throughout it draws the distinction of outdoor advertising being off-site advertising, being where a business is selling advertising on their property to third parties, and on-site advertising being what we have up and down the street already, which is stores with their signs out, just like we have, just like there. We have the T. Gregory import sign. It's the sign for that store. We have two of them right there, right? And there's no prohibition against those signs. And there's no prohibition again, and.
Well, there are regulations that regulate signage.
Correct. I don't disagree with that at all. What I'm saying is this prohibition, the prohibition of the business of outdoor advertising is not applicable to a business that has its own signage up and has a welcome flag, and we can look at the pictures that, if you would like to scroll back, Ms. Beaver, so we can see the pictures. It doesn't say anything about a prohibition about having some chairs outside the front door. It doesn't say anything about a prohibition of having like a sandwich board sign, that A-frame sign that welcomes people in.
The sign code is listed in regards to A-frame signs. You're not in the central business district, and if you also look up under the sign code, A-frame, it specifically states that if you're not in the central business district, A-frame signs are not allowed.
So I looked for that, and I know you and I talked about it, and I'm sure you're. Well, I'm just saying I've looked for it, and I couldn't find anything that. I'm sure that.
Under A-frame signs.
Okay, so I didn't find that, but what I did find is later in this document that I've shared here today.
Which one?
I'm sorry, in the ordinance that we've just been talking about.
The 2015 ordinance?
Correct.
Okay.
So, and I think that's the one that's applicable because it's the one that's cited at the bottom of the code when you go down and you click. So I'm quite confident that's the one that's applicable. There could be something else applicable, but I haven't seen it. If you go towards the back, there's an Exhibit A. And if you turn to, let's start with, Exhibit A, page 4 of 35. Actually, I kind of skipped some stuff that I wanted to make a point about. Let's see. Back before Exhibit A, if you'll go back to page 17 of the document as we were talking about, that's where it talks about at section 10, it says that section 34-342, in accordance with all these whereases that we just reviewed, is revised to add K. So that's when K was added. And it talks about that there on page 17 near the bottom, section 10. So then we flip over and we get to Exhibit A. And we go to page 4 of 35, Exhibit A, page 4. And it says, the only thing it really says for 3-4-4-2, wait, hang on a second. Yeah, at 3-4-4-2 it says, words and phrases not defined otherwise essentially will have its commonly understood meanings. And so, and I may have I think I misread that's, I don't know that section is actually applicable. But in any event, we'll flip to the next thing I underlined, which is at page 11 of 35, Exhibit A, is where it talks about flags and flagpoles. And
Are there
didn't.
revisions made?
I'm sorry?
I don't have it in front of me, so I'm asking, what is Exhibit
It appears to be, it's Exhibit A to the ordinance, which adds definitions, sign standards at page 1, and then it goes through, and I believe makes
Is it showing
amendments.
the specific changes to the code, to the city's code? Is that what Exhibit A does?
Admittedly, it is not clear what Exhibit A is doing. I think that it is showing the changes to the, I think that it is showing the changes to the code, that is correct.
So,
And also
Does it
giving some
also-
definitions.
then are the only changes in that 2015 ordinance to 342K?
That appears to be the only thing that's applicable, and it
No,
appears,
that's not what I asked.
oh,
I asked, are there other changes in that 2015 ordinance that, in addition to the change to 342K?
I believe there are some other changes, but I don't think that they're relevant or applicable.
Well, you just mentioned flags,
Mhm.
and could you, on page 11,
Correct.
what does that do?
Flags on page 11 appears to give some specificity about what is allowable. So it's under 12, signs and, no, it's under, no, it's 14, it stands alone. And it says flags, flag brackets, flag stations, and flag poles, and it talks about for each parcel and development in a residential use of one.
So
I think this is just, I think that one's related to residential.
So not having the ordinance in front of me, it sounds to me like it does more than just simply affect provide for the addition of 342K.
It does, I agree,
And
but I
there's
don't think that,
some provisions that apply to other sections of the ordinance code, is that correct?
yes.
What other sections does it apply to?
I didn't really study the other sections, Your Honor, so I could take some time to do that, but I looked
Well,
for
but
what
you're
I thought was
saying,
applicable.
but your argument is that the purpose and intent was only to prohibit businesses like Clear Channel. But it sounds like there's other provisions that were also addressed in this same ordinance.
So I looked through the ordinance and did not see something that I thought was applicable in the way that we're discussing it.
Okay,
My primary point of my argument is that the plain language of the ordinance, which says prohibited use, the business of outdoor advertising, is not applicable to the facts and circumstances underlying the citation. And so that citation, it seems to be incorrect. And then in reading that ordinance, it seemed to be, when I was looking for some explanation of what that meant, that the legislative intent or the council intent was to prohibit billboards as I described. So that's what I think the relevance of this document is.
I'll have to take a look at the ordinance to determine whether or not I agree with your,
Sure.
your position.
Well, I understand. I understand. And another thing that I found to try to help understand what K means is the FDOT, the Florida Department of Transportation, also talks about outdoor advertising. And actually you have to get an outdoor advertising license if you want to have billboards and those sorts of things. So on their website, it's frequently asked questions, and take it from for what it's worth, Your Honor. But if I may, Judge,
That's fine.
I have
Yes.
a copy for you.
I'd like to see it.
Yes. May I approach?
So far, the only thing that I've received, I have not actually received the ordinance, 2015.
2015.
Which is the amended sign code.
Oh, I'm sorry. I thought I brought it up to you, Your Honor, but
Oh,
I hadn't done it
first sentence in this ordinance says it's an ordinance relating to signs.
Correct.
So it does more than simply the business of outdoor advertising.
Correct. But,
That's what I asked earlier.
well, I think, if I wasn't clear, I meant to agree with you that it does more than that. But as it pertains to K, it amended it to add K, and it talks about throughout the distinction between off-site advertising and the business of outdoor advertising versus on-site advertising being advertising by the business that's at that location. I think that's the many whereases that I cited, and if it would be helpful to you, I can point you to the pages again. I'm sorry, I thought you had that in front of you when I was reading through it before.
And now you've also presented something entitled Outdoor Advertising Frequently Asked Questions
Correct.
From the FDOT
Yes, Your Honor.
website.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
And where did you obtain this?
I just went to the FDOT. I found this on the FDOT website, and I thought it was pertinent because if you'll see, and I've highlighted it near the bottom.
My question was, when did you obtain it?
Oh, this morning.
This one. Okay, go forward.
So I thought it was pertinent and instructive to help us understand better what is meant by the business of outdoor advertising. And if you look at the highlighted section on the front page, on the first page, it talks about anyone engaging in the business of outdoor advertising in the state of Florida must hold a license from the department. If you build outdoor advertising signs or structures or receive income from sale or lease of outdoor advertising signs or sales, then you're considered to be in the business of outdoor advertising. I found that very instructive because as I was looking and hunting to try to understand what K meant, again, the violation is you violated 34342K, which is prohibited use, the business of outdoor advertising. I was trying to wrap my brain around how the business of outdoor advertising was actually being conducted on that property, and it seems to me it's not. And so that's where we're going with this discussion. It seems that in the frequently asked questions by the FDOT, they've said this is what outdoor advertising is, which is what I described to you, actually being in the business of selling outdoor advertising. And then in the ordinance, whereases, the many whereases that we discussed, what I found pertinent and relevant in that ordinance is two things. That's where K was added, and in the discussion about all the many reasons the City of Jacksonville Beach has to make the changes that that ordinance made, including adding K, the council drew an important distinction between the two kinds of advertising. So my argument is having some chairs and some items out front, having a welcome sign, even having the sandwich board that says welcome, we're open, come on in, and it's inviting, is not the business of outdoor advertising, and rather it is in furtherance of on-site promoting the business that's there and welcoming people in and letting people know that we're there. And I have a couple other pictures that I'd also like to share.
What was, so you had chairs, you had welcome flags, and what was the third item that you just referenced?
Basically,
A-frame sign.
they call it the sandwich board sign. I have a picture I can show you. There's a
But in
picture,
the-
it's there, right there.
In the ordinance, it's listed as A-frame.
And which ordinance is that?
It's under the sign code.
And what chapter is that?
That I don't have the ordinance right in front of me, but it's under signs. I can look it up. Oh, I didn't bring my phone with me. And as I stated to Mr. Poe, it was a courtesy, he was not cited because he was a new owner. It was a courtesy, as stated in the email, letting him know what the sign code stated in regards to the flag and the A-frame sign. And during our phone conversation, I explained to him where it states in our sign code that the A-frames are not allowed outside of the central business district. And I will forward that ordinance to him once I'm back in the office.
And I would be glad to read that. I looked for it and couldn't find it, Your Honor. But
Okay, I 444, parens 15. Is that part of the sign code?
That's part of in regards to the flag.
Is that part of the sign code?
Yes, ma'am.
So does that mean that chapter, is, in other words, is, let me find that again. 444,
Yeah. Up under 444, you'll find the A-frame as well. Can I approach? If you have it, yeah.
I'm trying to see whether or not I happen to have a copy of 444. Hold on a moment.
That's totally good, but there's also a section in regards to A-frame that specifies if you're not in the central business district.
So 444 is part of Division 4 of your code, of the city's code, I should say. And Division 4 is entitled Sign Standards. So I haven't looked at this completely, but it seems to me that this is probably what the city refers to as the sign code. Is that correct?
Correct.
Okay, so, I see that 34-444 is entitled Prohibited Signs. And it states that the signs and sign types listed below are prohibited within the city limits, shall not be erected, operated, or placed on any property. Any lawfully existing permanent sign structures or sign type that is among the prohibited signs and sign types shall be deemed a non-conforming sign, subject to the provisions of 34-450 non-conforming signs. And you referred to 15, and 15 is, as you say in your email, flutter signs. Is this where we are going to find also the provision for the A-frame?
Correct. There's a list that goes down, I don't know what letter it is, but, up under prohibited signs, as you go down that list, I can't remember exactly what letter, A-frame, but, if I can approach. I can.
Yeah, you're more than welcome to. And you may
Russ?
also, if you wish.
I would like to. While she's looking for that, may I make a point about 15 that we were, the 15 section we were just discussing?
22, A-frame signs. Yeah. And it also states about the central business district.
Okay, here's number 22.
22?
Yeah, that's what she's referring to. So I'll wait for you to read that.
So, I would say.
Please go back to the, so that it gets recorded. Go ahead, so you don't forget.
Thank you. I believe at the end of that provision there, number 22, it talks about over a public right of way. I don't think that's applicable to an A-frame sign that is outside our door.
If you are in the central business district, other than that, it is listed under prohibited signs, which it reads in the ordinance.
I think we have to go by the strict reading of the actual ordinance. And I think that, I'll let you read it, Your Honor.
it's,
So that's the
this
exception.
section 22, begins with the word signs in, on, or over the public right of way. Then it states, other than fixed projecting signs in the CBD and the redevelopment zoning districts, comma, traffic control device signs, comma. It's got a whole list of different safety signs, warning signs, vertical street light banners, A-frame signs, T-frame signs, and awning or attached canopy signs over a public right of way as allowed in this division. So the exception is for signs in, on, or over public rights of way. There may be other provisions that relate to the A-frame signs, but this section 22 seems to be a prohibition against signs in, on, or over the public right of way. And then it has the exception for certain types of signs that are located in CBD or redevelopment zoning districts.
And so I would imagine that would apply when you've got a cute little restaurant and you want to put your A-frame sign in the walk, in the sidewalk, in the public right of way. But we have our sign right next to our front door, not in the public right of way. Right, so I think that's the distinction.
So you're saying it's not in the right of way?
I'm saying it's not in the public right of way as contemplated by that ordinance, that's correct. There's a sidewalk that is next to the street between the building and the street. I'm not willing to go so far as to say it would apply there, but I would understand the argument if we put the sign in the sidewalk, right? But we have the sign next to our front door, which is not in the public right of way as contemplated by that ordinance.
Ms. Beavers, are you prepared to testify about the A-frame or the flag?
So from the definition that I received from the planning and zoning director.
For
That-
what? The
for-
definition of what? The definition.
Oh, for A-frame signs, is what I was told, that if they are not in the central business district, they were not allowed.
Okay, so.
But I will get clarification from her in regards to section 22, if there is any other provisions throughout the prohibited signs that states, because I've always been told her interpretation is that they are not allowed at all if they are not in the central business district.
Okay.
And that's what's
I
challenging.
don't want to take the time right now to try to read this.
Sure.
Section on the prohibited signs. I think that where this is going is that let me stop. I'm going to allow you to finish, and then if Ms. Beavers has any comments to add, then at that point, we'll decide where we're going.
Understood, thank you. And again, I'm just trying to find the bounds of what is or isn't prohibited, which is where the conversation started. And again, Ms. Beavers was very helpful in providing the information that she had, and I appreciate that very much. But I think a challenge here is enforcement is operating on interpretations that are being told as opposed to, when you look at the plain language of the actual rule, whether or not we're in violation. And why this matters, we're not trying to be difficult, but I can also tell you that why this matters is, and I can show you some pictures that help make the point, is this makes a very big difference for our business and for lots of businesses up and down the streets of Jacksonville Beach, because it's the difference between our store looking open and our store looking closed. And I would like to show you some pictures that sort of illustrate that. And they're just different pictures from, if I may approach.
Yes.
And if you want to approach as well, Ms. Beavers, I'm just going to show her some different pictures in case they come to the store. Is that all right with you?
That's fine.
So, this is the front of our store.
states that if every business was to put all their merchandise outside, that would increase their sales. That's not the look that Jacksonville Beach wants in regards to merchandise. Your signage is what lets people know that you're a store, that you're there.
I'm
So
gonna show you these pictures.
that's, I mean, I've seen them, that's fine. But if that's the case, then the grocery store Publix would put all their merchandise outside saying, oh, we're gonna increase our steak sales because we put steaks and other perishables outside. I don't
So-
think that's what the beach wants.
I can make the same point again. Here's some things outside, inviting people in. Welcome to T. Gregory Imports. Some of our wreaths on the door. The chair's not out there, but it's welcome. This is what it looks like if we bring everything. It can't be that that's what Jacksonville Beach wants to have.
Your Honor, can I also state what I also mentioned to Mr. Poe is that he is allowed 6 tent events per year for outdoor sales, where he can apply for a tent permit. He can have outdoor sale events where he can place his merchandise outside during that time period. That was also
Right,
expressed to him.
okay, so,
And then we
Are-
have some other ones.
we got any of these?
No, not those ones.
I don't really need those. I mean, do you want me to keep them?
Sure.
Okay. We have a lot of exhibits for this one.
So-
But I do want to ask, since Ms. Beavers brought it up. So we've now talked about the section in the code that deals with the zoning district itself. That's 342.
Yes.
We've also talked about Part 4 sign code provisions at 444. And now I have a question about outdoor merchandise. Is that a separate section of the code?
What I was given, that was interpreted by our director of the planning and zoning department, was this section, which is 34, 341, the prohibited use, the business of outdoor advertising, and they're looking, in her interpretation, the merchandise is considered outdoor advertising.
Okay. Thank you. Okay, back to you, Mr. Poe.
Thank you, Your Honor. And I know this has gone long, but I have a few points I want to make. And again, it's in the interest of, this has a real and tangible impact on our business. As you can see, the way it looks from the photos, and anecdotally, there's a real impact on customers coming into the store, depending on whether or not we put some things out and show that we're open and look welcoming versus look basically closed. And then, so on my first point, I think there's not a violation by the photos that the city has presented. I think these things do not constitute a violation of 342K. Nor of the prohibited signs, which I meant to bring up to you as well. I think you have it in front of you, but the sign restriction that you read that talks about flutter signs, feather signs, streamers, balloons, wind signs, wind activated banners, cold air inflatables, pennants, and other fixed aerial signage used for commercial advertising.
Okay, I'm going to ask you another question about
Yes.
nor of prohibited signs, and 444, and you mentioned the A-frame. What about the welcome flag?
Correct. So I don't think that the A-frame is a violation for the reasons we've just discussed. And that's what I was just getting to, so we're right on the same page. The provision 34444 that I just read from, The end of that section, 15, says used for commercial advertising. I don't think that a welcome flag is contemplated by use for commercial advertising. It's welcoming people in like a welcome mat. It is, if it was another T. Gregory sign, then maybe that would be a different kind of distinction. But I don't think that that applies to a welcome flag. Just like I don't think it applies to, and I have a picture of, if I may approach this picture.
And which one did you say you don't think the welcome flag applies, which section?
I'll bring it up to you, 34444.
I've got that. Which subsection?
The American flag is not a violation.
15.
15.
Yes.
So if I may approach, Your Honor?
One moment. Let me ask you about that position. On the one hand, you're saying you need these outside in order to promote your business, in order to have a better business, to, and without those, it will impact negatively on your business. How then do you say that this particular flag, the fluttering flag, all of a sudden now is not commercial advertising? When you just said that without it, it's we need it there to help our business.
There's a distinction between making the store inviting and welcoming and alerting people that the store is open, and advertising. I couldn't buy an ad for a welcome, I could, I suppose, but it would hardly be advertising to simply have an ad that says welcome, right? It would have to say, more to really be an advertisement, not you. That's a distinction
Isn't
that I make.
the real purpose to attract business, just as you just said, to attract people to come into your store?
It's certainly, it is to attract people to come into the store, to welcome them in.
Stop right there. Okay. Okay, there's something else you want to show us?
Yes.
If I may approach.
Yes.
I showed this picture to Ms. Beavers, and I think she said that an American flag would not be a violation. It's hard to imagine that the welcome flag, is a violation of an advertising sign. But if that's a distinction that we'll draw, then, respectfully, I disagree, and I can move on to other points. But I've seen, I'm sorry. I wanted to point this out. I think you have.
So what you're saying,
This is where it is for commercial
is
advertising.
this what you're saying, just for clarity? Please go ahead.
Yes.
Is your argument that if American flags are exempted, then fluttering banners should also be exempt?
I'm not arguing for a fluttering banner. I think the welcome flag is a flag, and I don't think I'm not sure that falls under the same category as a fluttering banner, but
What do you think it falls under?
I think it's a welcome flag. It's a flag. Banners are, I would imagine, when you have,
So now we're arguing what is and is not a fluttering.
This wind activated, it's a wind activated flag.
I will concede that if that flag said sale or some other more advertising lingo than welcome, then perhaps it would fall under that restriction. My position is that I think welcome is more like a welcome mat, and it's not a violation. It's not really an advertisement other than to say we're open. And that's the point on that one. So, on, so in sum, on our first point, the conditions presented by the city, respectfully, we contend that is not a violation of the statute cited, 342K. Or a violation of any of the ordinances cited in the prior order. Also, respectfully, I disagree that I'll skip that argument. The next point I wanted to make was about selective enforcement.
Could I clarify, you just said you're withdrawing that argument
No,
about?
what I was about to say, I'm sorry. I'm not withdrawing anything I just said. I started to say another point and I decided not to. That's what I meant.
Could you go back to your statement then about the prior order? Is that the one you're?
Oh, I started to say, no. So the prior order
I
lists,
understand you don't think it's a violation of 342K.
correct.
Okay, what's next?
I also do not think it is a violation of any of the ordinances listed in the prior order, which is 34, 34, 2B, C, and D, which don't restrict.
Okay.
Those are about permitted uses.
Okay.
For example, B6 talks about being a home furniture store being a permitted use. You don't see anything in B that would be by the circumstances presented as of, I guess it was May 2nd is the date and issue. Likewise, C and D appear not to be applicable.
I gather your point on that. Could you move on?
My next point is about selective enforcement. And the point there is, and I have many, many pictures I can show you, but I won't bore you with that. You can drive up and down 3rd Street and see, and as Ms. Beavers understands, there's many stores with similar signs outside. And I'd like to ask Ms. Beavers, I kind of didn't finish, I'd like to ask, how many violations of 34, 342K were issued in 2024 so far?
I don't have the exact number, but if you want a copy of every single letter that I sent to every single business that had outdoor sales and display, I'll be more than welcome to send that to you. Because I believe you did an open records request. So in that open records request, if you want to specify the items that you would like, we can give you everything that you're requesting. And I can include every letter that was sent to every business that was cited for the same thing.
Okay. And that is correct. I did submit an open records request because they do want to understand more of how this particular provision is being enforced. And I think that's important to actually get to the heart of the selective enforcement argument. So with that outstanding.
When did you file your public records request?
Last week.
Last week?
I think it was on Thursday, but I just got the notice of this hearing the Friday prior.
So is it, I'll ask you, Mr. Pope, has it been responded to yet?
I got a response indicating that they received it and that I would get a further response. I have not.
It also needs to specify exactly what he's
Well,
requesting.
I'm sure the clerk will be dealing with those aspects, Ms. Beaver, to clarify his public records request.
Oh, because from my understanding, it didn't specify exactly. He just wanted everything in regards to this case. It didn't specify in regards to the selective enforcement that he's referring to that would include other businesses that were cited for the same thing.
So you didn't ask
That public records request did not specifically ask for records related to other citations, but I think that that's.
Okay, so the question to Ms. Beavers today, which was how many letters or, have been sent or actions taken in regards to 342K, that didn't have anything to do with your,
Open records request.
that wasn't specified in your public records request.
It was not,
Okay.
that's correct.
And then, so.
However, go ahead,
So
sorry.
I heard Ms. Weaver say that there have been numerous ones. She doesn't know exactly the number. So that's at this point. And you said in 2024.
Do you know approximately how many? I mean, are we talking over 5 or over 50? Do you have a range that you have a guess?
It could range from possibly 10 to 15,
Okay.
if not more.
Okay. Do you recall, this is right across the street from our store. It's fine wine and craft goods, so they're right across the street from our store. And this picture was taken on the same
We
day.
need you to be speaking
I'm
into
sorry.
the microphone.
This picture was taken on May 2nd, the day that this violation is at issue. Did you also send these folks a letter for their A-frame sign?
I did not see that.
I'd like to submit this picture, Your Honor. It's my testimony that this is a picture that was taken the same
May
day.
I take a look at the picture?
Yes.
Is there a date on the picture?
There is not a date on the picture, Your Honor.
Okay.
Unfortunately.
And also, who took this picture?
I believe that's a picture I took.
You believe or you
Wait.
did?
So, let me look at that picture again 1 second. This is a picture I took,
And when?
but it was a couple days later. It was after I received the citation, so it would have been on,
You didn't receive a citation
I mean,
for
the
your
notice,
A-frame.
I'm sorry, the notice here.
Okay, the notice of hearing didn't specify anything. That was just a conversation we had over the phone and through email.
I misspoke when I said same day. That picture was taken, I believe it was Monday or Tuesday of last week, which I can look at the date. I don't recall what that would have been.
I'm trying.
I can look at my phone.
13th and 14th?
Approximately, yes. It was, we
And
received,
you took this picture?
yes, I took that picture.
And do you know what's the address of this place?
I know it is immediately across 3rd Street from our store. I can look up the address pretty
Okay.
easily.
And what do you want to say about this picture?
That there's also an A-frame there on the, right outside the door. And at this point, I don't know whether or not they've also received the letter. It sounds like Ms. Beaver says that,
I did not
testimony,
see
she
it.
didn't see it.
That is not-
And I understand, you're just one person, I get that. But how do you come to know about violations? Is it based on complaints?
We're complaint driven, or if it's something that I've actually seen.
Okay, so with T. Gregory Imports,
It was a complaint.
there was a
An
complaint.
initial complaint in regards to outdoor sales where during COVID, other businesses were cited for outdoor display and sales, and they did exactly what you are doing. Well, what about this business? Well, what about this business? And your business, along with several other businesses, were pointed out for the same violation.
When was the first time, my understanding from the records you've shared with me is that the first time you cited T. Gregory Imports for this sort of a violation was in September of 2023, is that correct?
I believe so.
Okay. Do you know who you received the complaint about T. Gregory
I don't
Imports
have it
from?
in front of me,
Okay.
but I did get it was a complaint.
Okay.
I want to say it was that is down, she is located near Monkey Uncle.
Is it possible that the complaint came from someone at Teak Plus Outdoor Furniture?
I'm not, no, it was a female. He was cited for outside display. He was a new business. He was not aware of Jack's Beach City ordinance. Once he was cited, he immediately complied the violation.
Because what's interesting is that Teak Plus Outdoor Furniture is a store that's, up the street, and, they sell teak furniture like we sell teak furniture. And it seems that shortly after, according to Sunbiz, they opened up in about June, July of 2023, and it was shortly after that that we began receiving complaints about having some furniture outside. So I was wondering if that might be who the complaint was from. You don't recall if it was them? or
I
not?
just stated there was a yoga store that is down there. I want to say it's Monkey Uncle, or it's near the acai store that was cited for an outdoor display. She had a clothing rack outside.
Okay, I think we need to wrap up.
Sure.
We've now been on this item for a substantial amount of time.
And I appreciate it.
I think that I'm a little concerned about the efficacy of the argument about selective enforcement. I just have some concerns about whether that's really, part and parcel of this particular hearing, or relevant to this particular hearing.
I think the point is I don't know, and I gathered a little bit extra information. I'm sorry, I didn't interrupt you if you were continuing. My apologies.
And the conjecture, even you have said, it seems this, or it seems that, that the conjecture that this is your competition filing complaints, we don't have any evidence of that at this point in time. I'm not sure that the evidence that you have produced is one sign that has an A-frame sign out front. Not clear to me whether or not this business has been cited in the past. It's not clear whether it's been cited recently. So, we do have evidence or testimony that says that the city enforces their codes through complaint-driven process or by visual observation, I guess I would use, visual observation by the code enforcement officer. So, I think that, given that, I have some skepticism about, that this is somehow you're being targeted by
Point of clarification, I don't have any reason to think that the city of Jacksonville has it in for my store. The city of Jacksonville Beach has it in for my store. But I do think that the process of being complaint-driven lends to arbitrary and capricious enforcement because it lends itself to competitors targeting each other, for example. I don't know, and I'm not gonna go out on a limb with conjecture, but I thought there were fair questions to ask. I didn't make the argument that I don't have the evidence to support at this time that that's where those complaints came from. So I was asking the question to see if Ms. Beavers knew. We have some reason to believe that it may have been, but that would be hearsay if I were to get down that road, and I really don't want to detract from the main arguments. I do think that there's a process. First, which is why I addressed it first and it took as long as it did, you don't think there's been a violation. You don't think that the circumstances exhibited on May 2nd violated the ordinance cited or another ordinance, but that's not really relevant. It's, did we violate the ordinance cited or the order, which cites certain ordinances that also weren't violated by the items that were outside. I also, procedurally, I'm sorry.
Go ahead.
I think, when you answer that question, that there's not a violation, then we don't get to the selective enforcement. If the court were to find that there was a violation, then I do think that the selective enforcement may have legs, but would require further discovery. We only got notice of this, I think, still less than 2 weeks ago, of this hearing.
So since you brought it up, what do you think would constitute selective enforcement?
Selective enforcement would be if the selective enforcement, as I understand the legal definition essentially is, that if the city is aware of similar violations and is not enforcing against those similar violations the same way. It doesn't necessarily mean targeting, although sometimes that is the circumstance. I come from, for the past 10 years, I've been representing community associations in various forms of litigation. And selective enforcement actually comes up a lot in those contexts. And it's not dissimilar from this circumstance. It's not necessarily targeting, but it is if they're aware of certain violations and treating those violations differently without due cause, then it's arbitrary and selective. So the example I showed, and I believe I've got a stack of other photographs of similar situations, but I understand that Ms. Beavers is only one person and it takes a lot of people to tackle enforcement. I get that. But at the same time, if it's just complaint driven, then that leads to arbitrary enforcement because it's not necessarily the city is basically an abusive process. The city is being, complaints are coming to the city by somebody targeting somebody else, right? So that is a possibility, and that would be something that could be explored through further discovery, which if the court found that there was a violation, then I think that it would be appropriate to have an opportunity for further discovery on that. But the key argument is they don't think it's a violation, as we've discussed.
And just for clarity, you don't think it's a violation of 342K?
Correct.
You also don't think that it's a violation of the sections that were cited to 342B as in boy, C as in Charlie, or D as in David, that were cited in the prior order. And in regards to 444, you don't think that any of the signs, if you will, the banner, or the A-frame are violations, are not included in the prohibited signs
Correct.
section. Is there anything else?
minutes real quick. No, Your Honor, I believe that covers it.
Okay, thank you. Ms. Beaver, do you want to add anything at this time?
No, Your Honor.
Okay. I think that, there were a number of items that were referred to in regards to the land development code. We do not at this time have the person or anyone from the planning department to testify in regards to what those provisions mean. And, because it is the planning director, if I remember correctly, it is not, well, what I can say is it's not Ms. Beavers who interprets the land development code. It's probably either somebody like the city manager or the assistant city manager or the planning director or somebody in the planning department, likely, is the one who interprets those provisions. So in light of that, what I'm going to do, I'm going to withhold my decision. However, what I would like to do is bring this back in June and ask the city to have the planning director or the appropriate person who interprets the land development code and the provisions that we've been talking about. Either, you know, and when I say what we've been talking about, it's, you know, the 342, it's also the 344, it's also the sale of, or the display of merchandise outside the building, which has been discussed here today. And there may be other sections that are relevant to this, to the situation that, you know, is shown by the May 2nd, photographs that Ms. Beaver has put into the record. So, I think that that would be, the appropriate thing to do at this point. If we can't do it in June, which, may I ask the clerk, what is the date of the June meeting?
Your Honor, can I also recommend something as well?
Absolutely, you
Okay.
can. I'll let both of you
Okay.
speak to it.
June 26th.
June the 26th, it would be a Wednesday.
Yeah, look at my calendar.
Yes, please, you may. And also you can too. Obviously, it could depend upon if somebody from the planning department's even available then.
Christian, yeah, I would, Heather, the director, would not be available, but Christian probably.
Might be.
Mhm.
I would, of course, couch it that their availability, you know, would be necessary. I'm also going to check my calendar.
Okay.
I've put most of these things on my calendar.
The 26th sounds
Yeah,
correct.
I've got it on my calendar for
Okay.
the 26th. So, okay, you both want to say something about?
Well, I was just gonna recommend that until we come back in June and the code is interpreted, that the store remain in compliance, because what I don't want to happen, which has happened in the past, when other stores see them putting all their stuff and merchandise out, it's a domino effect. And all the other stores are gonna be like, oh, we can put ours out too. So until this June 26th hearing, I'm asking that the merchandise and the A-frame sign not be displayed.
Okay,
Likewise,
is that acceptable?
I would actually ask for the opposite. I would ask that well, as I expressed, it's impactful on our store to not be able to put anything outside our front door. And maybe Ms. Beavers and I can have a conversation about what would,
We're gonna
Sure.
try to decide before that,
right?
what would be acceptable.
He can apply for a tent permit if he wants to put his stuff out in between that time. So then that way, if another business sees that, I can say, well, right now, he has applied for a tent permit that allows him to have his merchandise out for 3 days, 6 times a year.
Do you have is there another option here, Mr. Paul?
My request would be that the compromise, if we're looking at this picture here, would be that we can have items in the A-frame sign up by the front door under that roofway. That chair that's out in the driveway, I'm fine with not, there's a chair out in the drive, in the
I
parking
see.
zone. I'm fine with not putting something there as a temporary compromise while we sort this out. But I think it's a reasonable compromise to say we could have a couple items outside our front door,
Let's
including
talk
a sign.
Let's talk.
Yeah, because it's gonna cause a domino effect. I see it every day.
Would you, and I'm, now,
Sure.
I'm just trying to find a happy medium between now and June 26th. I think that Ms. Beavers makes a very valid, has a very valid concern. I don't know that the 3 days, 6 times a year is gonna accomplish, because we've got more than 3 days between now and June 26th. I also think, Mr. Poe, that you are, you're asking the special magistrate and the city to let you do something that technically the city thinks is not lawful between now and June 26th. So I'm trying to find a compromise for this short period of time. And I'm feeling a little bit like, should I even be attempting to do this? But I want to find a happy medium, because quite frankly, by finding a happy medium for this in-between time, it means that any fine that you may incur, if that's where we end up, would be told during this period of time, if you would be willing to meet a compromise. I would suggest that you definitely don't have the chair in the nothing in the parking lot. Around your entrance, I think you could have the wreaths that you showed us in one photograph. I think that you could have the A-frame sign adjacent to the door, just like this is shown. I think that temporarily, and all of this is temporary, I don't think you should have the chair out there in front of the front door, and I also don't think that you should have the fluttering welcome banner. But it allows you to have what you described as something out there that allows you, in your belief, it's not my belief, it's your belief, that shows that the business is open. So, I have a real problem with the chair out there, with a for sale sign on it. I mean, with a tag on it. It's clearly merchandise that you're trying to sell. So I have a concern about that. I have a concern very much with the fluttering, whatever you want to call it, flag, banner, whatever it's called.
And right now, he did change it from the welcome flag to the American flag. So the American flag is allowed and can stay.
Absolutely.
So-
This has nothing to do with
right.
American flag.
So what you're saying is no chair, no flag, but right now the A-frame sign.
As long as it's where it's located here and shown in these pictures of adjacent to your entrance door. I think that, now, this has to be an agreement. You either have to agree, you don't have to agree, you can say, no, that's not really acceptable. You can offer another. But, you know, this welcome flag, and that's the welcome flag and that other one that I saw in the picture that is, you know, tall and kind of, I don't know how to describe it.
It's
I think it
right
was red.
No, it's
No.
this one.
It's down.
The other one was American flag that he showed you a picture of.
Oh,
That's
no.
right here.
There's a picture in here somewhere.
That's the American, it's the American flag, the red one.
No, there was another one. Maybe it was in your,
It was an American.
We only have the one welcome flag, Your Honor. That's the only welcome flag
Yeah,
that I know.
it was just the American flag and the welcome
I
sign.
made it up.
It's been a long, a long hearing, I understand. But that's the only welcome flag that I'm aware of.
Can you go back through your photos?
Yeah, this is all of them. So when the case started, it was an American
So I
flag.
thought that I saw something, one of those tall, they're like,
I know
6 or
what you're
7
talking,
feet tall.
he didn't have that.
okay.
Yeah, it's just been the
Okay.
flags.
Okay. So it's not a band, okay.
Oh,
This
see
is
that,
the blue one, go ahead.
I think what you're describing is what I think of as a flutter flag. It's one of those that goes in the dirt
Like a,
and it's like, it's kind of shaped like that.
yes,
I have some of those. We put them out at St. Augustine
okay.
because we were allowed to. We have, the welcome flag that we're talking about is just that one right there, which is why I compared it to the American flag, because it goes to the same place, it's the same size, it just says welcome. That was the comparison I was drawing.
So, I'm coming back, what do you got, you know, is between now and June 26th, you said you were available the 26th?
I do not have a conflict that I'm aware of on June 26th.
Okay, fair enough.
So, and I started with this, and I want to end with this. More than, well, very, very much, I want to reach an amicable resolution to this with Jacksonville Beach and be, continue to be great and good business citizens in this community. My understanding is the store's operated this way for over 20 years. I just bought it. Didn't know when I bought it that this order existed or that this issue existed. I just learned about it,
So
and it's
they never advised you?
about this citation issue. I didn't know about that. I didn't know about that order.
The employees are the same employee. Chris was
It is.
here.
So I will say that I know, we have the same manager.
And I had a conversation with him, and he knew it was not allowed. So he knew.
I have the same manager, and there's discussions about what you can and can't do. I was not aware of the order until Ms. Beaver sent me the order.
Okay. So, what about the compromise?
So, I'd be happy to reach a compromise. You're saying we can put it out. So, I didn't even know that the wreaths, frankly, are the wreaths considered a violation also? Okay,
Well, you showed them in your picture.
I did.
And I just wanted to make sure that you can put the
Because wreaths are seasonal. Those are seasonal items.
Okay, so wreaths, the A-frame board, and obviously we can continue to have the American flags out. And you're saying we can't have even one chair?
No.
I would request one chair if we can't reach a compromise on that.
What if, and,
It's gonna be a domino effect
what if?
of
there's no-
everything that I have done to notify all other businesses that they cannot have anything out.
that
They If it's a merchandise that they
Whether
sell,
there's a tag on it or not.
right, if it is merchandise that they
So you could have
sell,
a chair that's
so,
not for sale, that somebody cannot buy.
no, because then you would have to apply for outdoor seating. So it is a lot, it is a lot to
How about this?
interpret.
It's just for this period of time. I'm
Because everything that I've done to stop all the other businesses from doing, again, it takes one person to drive by and say, you told me I couldn't have this out here, so why are you allowing them to do it? And I can't say, well, the magistrate said they can do it for 30 days.
Special magistrate, actually, for a period of 30 days.
But then that's selective enforcement then, because then somebody else will say, that's selective enforcement, you told me I couldn't do it. And when I tell you, I went all up and down 3rd Street on anything that was not within the Central Business District, got a letter who had from tires to
So
any
your-
type of,
So your position, Ms. Peters, is that he can't have it
no ma'am,
just for this 30?
because it takes one day for one person to drive by and make it an issue that they were told that they could not do this, so why are T. Gregory allowed to do it?
Well, I think that what you could say, we are in enforcement with them currently.
And then what they're gonna do is, okay, well, I'm gonna put my stuff out as well. And that's what they do. Every single time, that's what they're gonna do. And I just, it's like you're running in circles. Because Chris said the same thing, his manager, he saw Dollar General. Dollar General changed managers. The manager did not know that they could not have charcoal and swimming pools out. So once I told them, they brought it in. But just like Chris saw it, he was like, well, they have it out. But the new manager didn't know, so what did Chris do? He put the furniture back out. It's a game of ping pong with these businesses. When one see it, the next one's gonna say, well, I'm gonna do it too, and they do it. So I don't think he should be allowed to put anything out.
Okay, thank you. I think I'm in a position where I can't tell you, Mr. Poe, what to do.
Sure.
You know, in light of the concerns that the city has expressed, which, you know, I understand, but I also understand your position. I think the better option for the special magistrate is simply to leave it in your hands, do what you think is appropriate, the best for you, and, you know, we'll see you on June the 26th.
I'm agreeable to reaching the compromise that you suggested. I tried for the chair, if the chair's not agreeable, if we can do what I think you said the wreaths are not a violation, so the wreaths are okay, if we can have the A-frame sign out until the 26th. I mean, I don't want to be crosswise with the city, and I hope, even though you probably feel like I'm trying to create a hardship for you, I promise you I'm not. I reached out right away to try to understand what constitutes a violation. And when I read the ordinances, as we've discussed at length here, these are not violations of the ordinances cited. So for us to be restrained by ordinances that don't seem applicable for another month and a half is a hardship.
I'm not going to, I don't want to put anybody in a worse position, either party, you or the city. I just don't. I probably went beyond what, you know, what my authority would be anyway to help the parties during this interim period of time. So I'm gonna withdraw the thought between now and June the 26th.
Can schedule a meeting to speak with the planning and zoning department.
Specifically, I think that would be an appropriate thing.
I would
Again,
love to do that.
I'm not going to advise you or tell you what to do, but I would encourage a dialogue to better understand, you know, so that both parties can better understand where they're coming from. I would love nothing more than for you to come back in June with, you know, a description that works for both of you, and that, so that Ms. Beavers can then tell me, like you heard earlier, the parties in compliance, you know. But I do think that it would behoove both parties to have a good discussion about about
The
provisions-
interpretation.
about the provisions that are in the code, that are applicable, maybe beyond 342K, right? Beyond that, the other things, the other provisions, the outdoor merchandise, you know, the signs, and then this issue about, obviously, 342K. So, I think that, unless there's any questions, I'm not even going to issue any kind of even, well, I guess I could issue a simple order that just says that the matter is going to be continued, and will be taken up on June the 26th.
Okay. And you can also put that, a meeting be scheduled between now and June 26th with the planning and zoning department and with the fire marshal.
And with the fire marshal.
Yes.
Okay. Is that acceptable?
Yes,
Okay.
I would love to meet with folks and try to get this sorted out.
Fire marshal, planning department. And maybe, you know, meetings and, continue to June the 26th. And that concludes this matter. And I was just gonna say, and I thought it was gonna be all the business tax that was gonna take up all my time. Thank you very much, both of you, for your attention to this, and I appreciate the efforts and the positions of both the city and Mr. Poe. And I think that concludes this particular matter.
And that
Is
concludes
there
all my
anything-
cases for today.
That's all your cases?
That's all my cases.
Okay, then I think we can close the hearing, today's hearing.
Thank you very much for your time and consideration.